Hi everyone, welcome. If you're watching this, the meaning is that I'm not in class. Something came up and I was unable to come, but I hope that you take this lesson seriously as you would have taken it if I was present in your class. Please, if you have any questions, put them down in the comment section. I'm going to go through them after a while and I'll keep answering. The reason is, if you put it down there, other people can benefit from this class. So for those of you who have the lecture materials, we will be dealing with chapter 7, basic principles of the law of contract. So we'll be looking at basic principles of the law of contract. When I say your study material, I mean this for those who have the book. This is what we're going to be using, and we will be on chapter 7. Chapter 7 is on page 58. So that's what we're going to be using in today's class. Basic principles of the law of contract. This chapter is segmented into various parts, and I'll just briefly run through the things that I expect us to know and note even as we study this material. We'll try and define what a contract is. We're also going to try and know the classification of contracts that we have. And then we're going to be looking at elements of a valid contract, and we will be considering contracts and third parties, and we would also be looking at vitiating elements in contract, and then we'll look at the contents of a valid contract, and we will wrap up by discussing discharge of a contract and remedies for breach of contract. So I'll take that again. We'll be defining what a contract is. We would also be looking at the various classifications of contract. We'll be looking at the elements of a valid contract. We'll be looking at contracts and third parties. We'll be looking at vitiating elements in contract. We'll be looking at the content of a valid contract. We'll be looking at discharge of contract, and we will be looking for at remedies for breach of contract. If we're unable to take all of that in this video, I'm going to break the lessons into other videos. But wherever we'll stop, we'll continue in the next one. And I'm going to try as much as possible to leave as detailed enough information as possible, so that if you jump a video, immediately you start, you know that you have jumped it. So this is the first video in this series of chapter 7. What is a contract? Basically speaking, a contract is an agreement between two or more persons that the law recognizes. So what makes a contract different from a conversation you may be having with somebody is the fact that the law would recognize whatever commitments that you have made or agreed to make when having that conversation. So a contract is an agreement between two or more persons that the law recognizes. For a thing to be a contract, there are things that must come to play. There has to be things involved in that conversation, in that write-up, in that discussion, in that negotiation that makes it important for the law to consider it as something that it should enforce. For a contract to be valid, there has to be an offer. There has to be acceptance. There has to be the intention to create legal relationship. There has to be consideration. And all of these parties involved in all of this must have capacity to contract. So for a contract to be valid, there has to be offer, there has to be acceptance, there has to be consideration, there has to be the intention to create legal relationship, and there has to be capacity. We're going to take that one after the other. But before we go into that, let's look at the classification of contracts. There are various classifications of contracts that we have, but for easy understanding, I have grouped them into 4 major classes. That does not mean that there are no others. Others exist, but so that we have a picture of what we're talking about, I've grouped contracts into 4 main classes. The first is a formal contract. A formal contract is that contract that is under seal. A formal contract is that contract that is in writing. A formal contract is that contract that is signed, that is sealed, and that is delivered. So it has to be in writing, it has to be on the seal, it has to be signed, and it has to be delivered. Most formal contracts are land transactions. So where you have an agreement for land or a deed of assignment for land, that may be regarded as a formal contract. Another example of a formal contract is when you have a contract with a company. So most employment letters that companies issues or whatever agreements companies get into, they are usually formal contracts. That's because companies are corporate entities that the law requires should have a common seal. So the presence of a seal makes it imperative that whatever a company is getting into has to be formal and it has to be sealed for it to be recognized under the law. Another class of contract that we have is a simple contract. Simple contracts are oral agreements, where two people just agree, I'll do this in exchange for this. Those are simple contracts. For instance, if you're looking for somebody to help you cut the grass, and somebody comes and says, I'll cut this grass, how much will you cut it for? And the person says, pay me 1,000 naira, and you say, no, I'll pay you 800, and the person agrees. That's a contract. When the person cuts that grass, you are supposed to pay. You can't start asking, where did I sign? Where did I write? Those kind of contracts are usually not in writing. Those are simple contracts. Another class of contracts that we have is the express and implied contract. Express contracts are contracts where all the terms of the agreement are clearly spelled out. So everybody knows what they are supposed to do in fulfillment of their obligation under the contract. Implied contracts, on the other hand, are contracts that flow from express contracts. What this means is that the terms are not usually stated, but they are inferred or they are implied or they are assumed from the express contract. I'll give you an example. When, for instance, you go to buy something, there is an express contract that if you pay the money you are supposed to pay, you are given the product that you went to pick up. That's an express contract. The implied contract that flows from that express contract is the fact that whatever you are buying has to be in good state. You should be able to use it. It should be fit for the purpose for which you want to use it. So if you buy a thing and you're unable to use it, whoever sold that thing to you has breached the implied term of that contract or that agreement, that this thing I'm selling to you, you can use it. So take for instance, if you buy a cream, maybe you buy a cream to clear blemish on your body or to do a particular thing on your skin, and when you use it, you get burnt. It turns out that the products that were used to make the cream were harmful to the skin. The person who sold that cream to you has breached the implied contract. The express contract is, this cream, this is what it does, pay this amount, the cream is yours. The implied contract is, if you use this cream, it will do this for you. So where it does not do this for you, then it has breached the implied term of the contract. And then we have the bilateral and unilateral contract. Bilateral contract, like the name implies, are contracts that exist between two persons. Unilateral contract is a contract made by one man to the rest of the world. An example of a bilateral contract is if I offer my car for sale and somebody buys the car. That is a contract between me and that person. A unilateral contract is me drafting the terms by myself, and anybody who is interested now performs whatever obligations you have to perform. That's a unilateral contract. I'll give you an example. There's this very interesting English case of Caliph against Carbolic Smoke Ball Company, decided in 1893, reported in Volume 1, Queen's Bench, page 256. In that particular case, Carbolic Smoke Ball Company, that's the defendant, They advertised in a newspaper that they were going to pay £100 to whoever uses their product and still suffers influenza within 2 weeks of using their product. And a particular person, Carly, just bought the product and used it and suffered influenza within the 2 weeks. And he went to the company to get his £100, and the company said, I don't know you, please. And then he went to court. The court now decided that yes, you advertised on the newspaper that whoever purchases your product and uses it and still suffers influenza within 2 weeks will be compensated with £100. Mr. Carly, the plaintiff, didn't have to call you or come to your company and say, I want to buy your product, I want to test it and see whether it works. He didn't have to. The fact that he put the information out there and he decided to get the product and use it, you have entered the contract. So that is a unilateral contract, in the sense that the company putting the advertisement out there has entered into a contract with whoever has decided to use that particular product. Elements of a valid contract. What are the things that make for a valid contract? Like we said when we're trying to define a contract, we say it's an agreement between two or more persons which the law recognizes. So when we talk about elements of a valid contract, we're talking about what are those things that the law would look at and say, yes, this is the contract that we should enforce, this is the contract that we should consider. That's what we're going to be looking at in this part. For a contract to be valid, for the courts to recognize a contract, all of these things must be present in that particular contract.